Can there be a cognizance after many years of the offence? Can the magistrate take the cognizance of the offence after finding that the FIR is filed after so many years? Can the magistrate take the cognizance of the offence if the prosecution fails to file the charge sheet for many long years? Or what is the time prescribed to take the cognizance of the offence under CRPC? The important question is whether the purpose for the computing the period of the limitation under section 468 of the CRPC, the relevant date is the date of filing of the complaint or the date of the institution of the prosecution, or whether the relevant date is the date on which the magistrate takes the cognizance of the offence. Dear friends, Vande Mataram. Welcome back to my channel, Courtroom Battles. It's been long time we have been discussing the provisions of the law and the various case laws. The discussion on this channel has immensely benefited the young lawyers and the citizens who have some sort of interest in the law. Dear friends, if you have failed to subscribe my channel and if you are interested in law, please subscribe this channel. Dear friends, what is the recourse available to innocent citizen if he has been framed illegally on the basis of the false allegations or the false FIR? We have seen hundreds and thousands of people are being framed illegally by filing false FIR against them. Most often it is found and observed that a citizen is very innocent but faces a criminal trial for as long as 10 years and then probably he may get acquittal. So what are the recourses available to an accused if you are facing a false case against you? Dear friends, if you are an accused or if you are a lawyer of an accused, then we have already suggested that immediately after getting the copy of the FIR, you should file writ petition or application under section 482 of the CRPC before the Honorable High Court and seek quashing of the FIR. Dear friends, you can seek the quashing of the FIR and you can also seek the quashing of the charge sheet if filed by the police authorities before the competent court. So section 482 gives powers to the Honorable High Court to quash the entire FIR if it is found and observed that the offences in the FIR do not in fact match the allegations. Dear friends, please watch my earlier video, how to quash the FIR under section 482 of the CRPC. Today we are going to discuss the provisions of section 468 of the CRPC 1973, which deals with the limitation. Dear friends, there is a limitation prescribed by the Criminal Procedure Code by which the magistrate is empowered to take cognizance of the criminal offence. Can there be a cognizance after many years of the offence? Can the magistrate take the cognizance of the offence after finding that the FIR is filed after so many years? Can the magistrate take the cognizance of the offence if the prosecution fails to file the charge sheet for many long years? Or what is the time prescribed to take the cognizance of the offence under CRPC, whether for the purpose of computing the period of limitation under section 468 of the CRPC, relevant date is the date of filing of the complaint or the date of the institution of the prosecution, or whether the relevant date is the date on which the magistrate takes the cognizance. This is the important question of law which we are going to discuss today. Dear friends, you will have to see the provisions of section 468 by which a clear limitation has been prescribed. This in fact creates a bar on the magistrate to take cognizance of the offence under CRPC. Dear friends, you should be able to use the weapons which are available to you in the armory under CRPC. Dear friends, 468 of CRPC is one such weapon which can be effectively used by the criminal lawyers to save their clients if it is found that there is a delay in taking cognizance of the offence by the learned magistrate in the trial court. So what is section 468? Dear friends, it creates a bar on the magistrate to take cognizance of the offence as similar to the Civil Procedure Code when we file an application under section 711 of the CPC in order to quash or to dismiss or to reject the civil suit. Order 7 Rule 11D specifically deals with the limitation in the Civil Procedure Code by which the suit which is filed after a period prescribed in the Limitation Act can be rejected and dismissed. The important question is whether the purpose for the computing the period of the limitation under section 468 of the CRPC, the relevant date is the date of filing of the complaint or the date of the institution of the prosecution, or whether the relevant date is the date on which the magistrate takes the cognizance of the offence. Akin to the provisions of 711D, can we in fact quash the criminal trial or the criminal offence against accused? Yes, dear friends, the provision is section 468 of the CRPC. What does section 468 says? The lawmakers have specifically created a provision of section 468 by which a magistrate is empowered not to take the cognizance of the offence, and there is a bar created in favor of the accused. Dear friends, 468 speaks about the limitation period to take cognizance of an offence, which reads as follows. 468, bar to take cognizance after a lapse of the period of the limitation. 1. Except as otherwise provided elsewhere in the Criminal Procedure Code, no court shall take cognizance of the offence of the category specified in subsection 2 after expiry of the period of the limitation. Clause 2. The period of limitation shall be A. 6 months if the offence is punishable with the fine only. B. 1 year if the offence is punishable with the imprisonment for a term not exceeding 1 year. C. 3 years if the offence is punishable with imprisonment for a term exceeding 1 year but not exceeding 3 years. Subclause 3. For the purpose of this section, the period of limitation in relation to the offences which may be tried together shall be determined with the reference to the offence which is punishable with more severe punishment. So dear friends, this specific provision needs to be carefully acted upon if you are a counsel of the accused. The clause A specifically bars the court to take the cognizance of the offence beyond 6 months if the offence is compoundable in nature. This is specifically applicable to the most offences under Motor Vehicle Act, or popularly known as traffic offences, where the compoundable nature of the offence itself makes it eligible not to take the cognizance under section 468 2 if the said traffic challan is brought before the magistrate after a period of 6 months. The clause B creates a bar for the magistrate to take the cognizance of the offence after 1 year if the offence is punishable with the imprisonment not more than 1 year. The clause C creates a bar on the magistrate to take the cognizance of the offence if the imprisonment prescribed for the particular offence is more than 1 year but does not exceed 3 years. So the gravity of the offence, in fact, deals with the limitation period. So dear friends, the important question is whether the purpose for the computing the period of the limitation under section 468 of the CRPC, the relevant date is the date of filing of the complaint or the date of the institution of the prosecution, or whether the relevant date is the date on which the magistrate takes the cognizance of the offence. This issue is no longer res integrata. 5 judges of the Constitution Bench of the Honorable Supreme Court has settled this issue in Sarah Matthews case 2014 to SCC page 62, wherein the Honorable Supreme Court, after considering its previous pronouncements in 2 important cases, that is Bharat Damodar Kale versus State of AP 2003 at SCC 559, followed in Japani Sahu's case 2007 7 SCC 394, which has laid down the correct position of law for the purpose of computing the period of limitation under section 468 of CRPC and endorsing the observations made in Vanakka Reddy's case. Dear friend, in Vanakka Radha Manori versus Vanakka Reddy and others 1993 3 SCC 4, the Honorable Supreme Court has also examined this issue, and in light of the legislative intent and meaning prescribed to the term cognizance by the apex court, it is made clear that the section 473 of CRPC postulates condonation of delay caused by the complainant in filing the complaint, and it is the date of the filing of the complaint which is material for the calculating the limitation period. Thus, relevant date is the date of filing of the complaint or the date of the institution of the prosecution and not the date on which the magistrate takes the cognizance. So what does that mean? Dear friend, which is the relevant date? If we go backwards, the period of limitation will have to be calculated from the date on which the FIR is filed or from the date on which the private complaint has been filed by the complainant against the accused. The Honorable Supreme Court in Vanka Radha Manohari's case 1993 3 SCC 4 has explained insertion of chapter 46 in CRPC and differentiated the provisions of section 5 of the Limitation Act and that of section 473 CRPC, and has observed that earlier there was no limitation period for launching the prosecution in the criminal case against the accused, but delay in initiating the action for prosecution was always considered to be a relevant factor while judging the truth of the prosecution story. But then the court could not throw out the complaint or a police report solely on the ground of a delay. The court introduced a separate chapter prescribing the limitations to take cognizance of the criminal offences. Akin to the Civil Procedure Code and provisions of section 5 of the Limitation Act, similar provisions were inserted into the Criminal Procedure Code and section 468 and 473 were introduced. So for section 473 of the code is concerned, the scope of that section is different. Section 473 gives extension of the period of limitation in certain cases. Notwithstanding anything contained in the foregoing provisions of the chapter, any court may take the cognizance of the offence after expiry of the period of limitation if it is satisfied on the facts and in the circumstances of the case that the delay has been properly explained or that it is necessary to do in the interest of the justice. So dear friends, similarly at the time of framing the Criminal Procedure Code, when the section 468 was prescribed, and a limitation is prescribed, at the same time, the power is also given to the learned magistrate to condone the delay while taking cognizance of the offence under section 473. So, the magistrate is empowered to take the cognizance of the offence or cognizance of the prosecution even after prescribed period of the limitation. So, when can the magistrate condone the delay? There are only two things which are prescribed in the Act, dear friends. One, the delay has to be properly explained by the prosecution while coming to the court. And two, if the Honorable Magistrate is satisfied that it is necessary to condone the delay in the interest of the justice. So, dear friends, only two windows are available for the prosecution to come forward and get the accused convicted after a delayed prosecution. It becomes easier, in fact, for the counsel of the accused to get past these two hurdles of the windows and then quash the FIR on the ground of the delay itself. Delay in taking cognizance can be allowed under section 473 of the CRPC. A three-judge bench of the Honorable Supreme Court in State of HP versus Tara Dutt 2001 SCC 230 has held that section 473 of CRPC confers power on the court taking cognizance after the expiry of the period of limitation if conditions envisaged therein are fulfilled. And those conditions are: 1. Where a proper and satisfactory explanation of the delay is available, and 2. Where the court taking cognizance finds that it would be in the interest of the justice necessary to condone the delay. These are only two factors, dear friends. While passing an order, the learned magistrate has also required to give entire reasoning if these two conditions are satisfied by the prosecution. If not, the reasoning has to be given adversely and the delay has to be rejected by the learned magistrate. It cannot be said that in every case the delay can be condoned liberally and which will be detrimental to the accused in facing the trial. The discretion available to the learned magistrate to take the cognizance of the offences beyond the prescribed limitation period by exercising the powers under section 473 and by condoning the delay of the prosecution will have to be exercised judicially and sparingly. While taking the cognizance of the offence and while giving the advantage to the prosecution, a detailed order, a speaking order, a reasoned order is required to be passed by the learned magistrate. So, dear friends, if you read the provisions carefully under 468 and 473, you will find that there is a ray of hope for the accused in this country to get the prosecution quashed or to get 100% acquittal of the accused even without contesting the trial for 10 long years in the criminal court. So, dear friend, this is the most important provision and the window available to the accused in this country by which he can get himself acquitted and get rid of the criminal trial without facing the trial itself. I hope you have liked this video. If you have liked it, please share it with your friends and relatives. Don't forget to share it with any of your friends who has been falsely implicated by the police authorities in a false FIR. Dear friends, we have created this channel specifically with the sole object and motive to create awareness among masses and the citizens in this country who are not aware about their rights. If you are an accused, you have certain rights. So today we have discussed the right to get acquitted or right to get relief even without contesting the criminal trial only on the basis of the delay or violation of the provisions of the limitation, that is 468 CRPC. Please subscribe to my channel and share this video with your friends and family. Thank you so much for watching. Continue watching Courtroom Battles. Jai Hind, Jai Bharat.